Hello everyone, I am Jennifer Stone, one of your Chicago title underwriters. I just want to say our team really appreciates and sees how hard you all work, and we want you to think of us as a resource and business partner in the rapid moving real estate market. If you were able to join us for our most recent webinar, then you heard our very own Terry Callan discuss joint tenancy with the right of survivorship. She talked about a newly issued Court of Appeals case in the matter of the estate of Thomas G. Moore, and I wanted to take this opportunity to break down a few components from that case. The quick background is that appellant and decedent owned a piece of property as joint tenants with a right of survivorship. Appellant and decedent executed a contract to sell the property in November 2013. Decedent died on December 20th, 2013. The property was sold and conveyed by appellant on December 27th, 2013, and he retained all the proceeds. The respondents argued to the probate court and circuit court that the execution of the contract to sell an encumbrance on the property and severed the joint tenancy with a right of survivorship, converting instead to a tenancy in common. The lower courts relied on the oldie but goodie case of Carolina Federal Savings Bank versus Sanibel Corporation that the purchaser under an executory contract for the purchase and sale of real property has an equitable lien on the property in the amount paid for the purchase price, and that the lien arises not by possession of the property, but by the payment of money. The lower courts extended that holding to find that the lien against the jointly held property severed the joint tenancy, converting it to a tenancy in common, and awarding half of the proceeds from the sale to the estate. In this order, the Court of Appeals analyzes Section 27-7-40A of the South Carolina Code, describing the impact of the statute on ownership of jointly held property, including specifically subsection 1, that a surviving joint tenant is vested with the entire interest in the real estate upon the death of a joint tenant. Subsection 3, that jointly held property may not be encumbered by a joint tenant acting alone. And subsection 4, that jointly held property may be encumbered if all joint tenants join in the encumbrance. Appellant argued that Section 27-7-40A-4 permits joint tenancies with rights of survivorship to encumber property, but that this permission does not sever the joint tenancy with rights of survivorship. Finding no South Carolina case law on point, the Court of Appeals looked to other jurisdictions, including Washington and Florida. Ultimately, the Court of Appeals held that jointly encumbering jointly held property does not sever the joint tenancy nor destroy the right of survivorship, and that the estate was not entitled to proceeds from the sale of the property. And that's all from me for today, but if you have any questions, please feel free to call us, or you could always email us at scunderwriting@ctt.com. Have a good one.